The strait settlement consisted of Singapore Island, Penang Island that is formerly known as Prince Wales Islands, and state of Malacca. Singapore was settled in 1819 on behalf of the British Crown. Penang was ceded to the British in 1791, although British sovereignty was only formalized in 1826 with the signing of Treaty of Bangkok between the British and Siam. The 1824 Anglo-Dutch Treaty formalized British colonialism in Malacca. The East India Company formalized the administration of these three colonies by 1825 until 1858, whereupon the Imperial India Office took control. The three colonies were referred to as strait settlements since 1867. The British occupation in these three states were formally strengthened and recognized under the Three Charter of Justice. The first Charter of Justice provided for the Court of Judicature to administer the common law and equity, which were then enforced in Malaysia. It was also provided that the common law and equitable principles will be enforced as far as the local circumstances will admit in Penang. The second Charter of Justice, this is provided for United Court of Judicature for the three settlements, and the above provision was emphasized for the benefit of Singapore and Malacca. The third Charter of Justice, this is provided for a reorganization of the Court of Judicature into two divisions that is specifically for Penang and Malacca and Singapore. Early land law in Penang. This island was a part of the state of Kedah, which was ruled by a Muslim sultan. It was occupied by the East India Company (EIC) through the negotiation with the Sultan of Kedah and fratricide in 1786. It happened because of the Sultan sought military assistance from the British government to protect the state from the Siamese attack. The Sultan finally gave the island to the British government through the Three Charter of Justice. According to the British, there were no formal land law in the state of Penang at the time whereby the East India Company occupied the state. This can be clearly seen in the case of Ong Chi Neo against Yap Chie No. The Privy Council was of the view that, in either view, the land of England must be taken to be the governing law, so far as it is applicable to the circumstances of the place. Court held that the island was wholly uninhabited when the British arrived. This is the English law should be applicable. Early land law in Malacca. Malacca was founded and developed by Parameswara under the rule of Muslim sultans. However, after having been occupied by Portuguese in 15th century and following by the Dutch in 16th and 17th centuries, and it finally fell under the British rule, who took over Malacca from the Dutch pursuant to the Anglo-Dutch Treaty of 1824 in return for handing over Bencoolen to the Dutch.
Unfederated Malay States (UMS) between 1909 and 1914, the states of Johor, Kedah, Perlis, Kelantan and Terengganu became protectorates but didn't join the federated states. In the Treaty of Bangkok 1909, Siam ceded Perlis, Kedah, Kelantan and Terengganu to Britain. From 1909 to 1946, including Johor, those states were called as the Unfederated Malay States, a term to differentiate them from the Federated Malay States and the Strait Settlements. After the Japanese occupation in World War II, the Federation of Malaya was established, in which the 5 individual unfederated Malay states joined Negeri Sembilan, Pahang, Perak and Selangor, hitherto federated Malay states, as well as Penang and Malacca, hitherto strait settlements, as member states.
There was no resident system in the unfederated Malay states, but a British officer was appointed as an advisor to help the officers administer the states under the federated Malay states residency system. Kelantan accepted the British advisor in 1910, Terengganu in 1910, Johor in 1914, Kedah in 1923, and finally Perlis in 1926. Prior to the British intervention, the Malay torrent system is a mode of conveyancing whereby the title to the land and interest in land depends on registration and not upon instrument inter partes. To register is everything, and any dealings must be registered in order to gain recognition. In the case of AB against Marutama, it was said that under the torrent system, to register is everything, and it would be wrong to allow an investigation as to the right of the person to appear upon the register when he holds the certificate of title. Judge Suryadi in Signed Bank against Muhammad Hassan bin Sulaiman said that the National Land Code 1965 was made effective from 1st January 1966, whereby thenceforth a uniform system of land tenure and dealing existed throughout Peninsular Malaysia. In a gist, the system practice is commonly referred to as the torrent system or the registration of title system. Three principles: the mirror principle, the curtain principle, and the insurance principle. However, the system that has been developed for the Malaysian land law has only adopted the two principles, that is the mirror principle and the curtain principle. The important characteristics of the torrent system, which are: first, details of the dealings of the land must be officially registered on the title of the land. Second, registration alone gives validity to the dealing by creating a legal estate or interest in the land. And lastly, all transactions must be affected by the use of stereotyped forms. The objectives of torrent system are: first, to overcome the defects in the deed system; second, to provide simplicity and certitude; third, to deter legal technicalities in land dealings; and lastly, to provide security of title and facility of transfer.
Federated Malay States between 1874 and 1888, the Malay states of Perak, Selangor and Negeri Sembilan accepted a British resident and were British protectorates. In 1896, they were federated with Kuala Lumpur as the capital. In 1895, British protectorates on the Malay Peninsula, namely Negeri Sembilan, Pahang, Perak and Selangor, formed the Federated Malay States. Johor, a British protectorate since 1885, opted not join. Neither did Kedah, Kelantan, Perlis and Terengganu, which became British protectorates by the Treaty of Bangkok 1909, as per explained before. From 1942 until 1945, the Federated Malay States were under Japanese military administration. With the re-establishment of British administration in 1946, the former member states of both the FMS and the UMS, together with Penang and Malacca, hitherto Straits Settlements, formed the Federation of Malaya.
The British intervention in the four states came about with the Treaty of Bangkok in 1874. This introduced the British resident systems where a British officer known as the resident is appointed for the states respectively. The advice of the residents must be sought and adhered to in all matters except for those matters related to Malay customs or adat. The courts have recognized that the Malay customary land tenure was the law of the land when the British came. Refers to the case of the Pahang Consolidated Company Limited against the state of Pahang 1933, in which Lord Tomlin held that the Sultan of Pahang is an absolute ruler in whom resides all legislative and executive power, subject only to the limitation which he has from time to time to be imposed upon himself. In the Federated Malay States, there are no charters of justice, and British common law was not introduced until the passing of the Civil Law Enactment No. 3 of 1937.